All rise. Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We are here for oral arguments in CV 20-0652. This is Power Steel v. Vinson et al. Counsel, these proceedings are being video and audio recorded and live streamed. So we ask you to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock, which is on the center podium there, if you'd like to reserve a portion for rebuttal. Also, please keep in mind that we've read the briefs and have conferenced the case this morning. And with that, counsel, you may proceed.
Good morning, Your Honor. William J. Quinlan and my colleague Eric Schmidt is here, as well as John Powers and David Jeezy on behalf of Power Steel and Wire. Your Honors, the core question we believe before the court is whether under a de novo standard and in viewing the evidence in the light most favorable to appellant that an officer, a director that had testified that he had met with a large steel vendor, reached an agreement in which that steel vendor would provide him $850,000 in a credit agreement, plus act as a depot, and in which that vendor testified that they had a meeting, that they discussed about how they were going to increase business into that area, and in addition, whether the facts and circumstances show that he was given a credit line, that Power Steel paid the highest prices, that that the board of director and officer, then when he started his competing business, paid the lowest prices, and that through all that, Power Steel was damaged. Their business is shuttered, and whether in the light most favorable, whether there were questions that should proceed to a jury. We stand to believe that there is more than enough ample evidence, both when you look at the evidence that occurred before Mr. Bill Powers left and after that he left, that those facts in the light most favorable to appellant in a de novo standard, that it would be appropriate for a jury to hear that. We believe that the trial court improperly weighed evidence, that properly determined credibility, and that those questions are left to the province of the jury. And we believe that...
Where you say he
Yes, Judge Morse.
weighed credibility.
Correct.
Where in the evidence was there a dispute that the trial court had to resolve? And I realize you argue some inferences based upon circumstances, but where is that weighing of credibility that you're referring to?
Well, the most basic is the affidavit that was filed by Bill Powers after the fact when summary judgment was pending to try and address his testimony that he made during an evidentiary hearing, for starters, which is, you're weighing credibility when he's, quote, trying to explain that evidence, when in fact he had counseled that evidentiary hearing,
Okay,
who
I
could have
understand
explained that.
So,
I don't mean to
because
interrupt.
usually when I say weighing credibility, I consider the circumstances. You have witness A says X and witness B says Y, and the court's weighing that. What you're saying is that the court weighed credibility in determining that the affidavit was more credible than the original deposition testimony.
Correct, Your Honor.
Okay.
Correct.
Well, let me drill down on that a little bit, just so I
Sure.
make sure I understand your argument. Does anybody dispute that his original deposition testimony was inaccurate?
I believe, and I can't obviously speak
I mean,
for Apple.
did you present any evidence? Because I know he said, and I don't remember the exact dates, he said in his original deposition testimony that we filled in that application in December, right? December of 2017 or 2018 or whatever.
You're correct, December 2017, 16th or 18th.
Right. But everybody acknowledges that wasn't accurate, right? There's no evidence to suggest that that is the date it was submitted on.
Well, two different, may I don't mean to.
Please.
Sure. I think there's a way, we need to unpack that if I may. And
Please.
So let me say first and foremost, when and where and how the application was submitted, at least on my position, is a red herring, right? The question is, so there's two questions. When did he sign it? Which he could have signed it December 16th or 18th, and then, again, light most favorable, and then submitted it in January, okay? But the purpose of the application, I think, gets lost in the trial court. With all due respect, I think the purpose, to be fair, is that what it does is it what's the word I'm looking for? It memorializes, thank you, I apologize, I'm having a senior moment. It memorializes,
I don't think you're any older than I am, so.
well, it's been a harsh excuse. It memorializes the meeting, the conversation, the agreement. When and how that application was submitted, that's not important, at least from our point of view, when you look at the triable fact. The issue is, did they have a conversation while he was an officer, while he was a director? Did he breach his fiduciary duty? Did he steal corporate opportunity? And was Vinson aiding and abetting? And so the purpose of that testimony in the agreement, Your Honor, is to say it memorializes, just like you would in front of a jury, and does that, and show it to a jury to say, this happened because, look, he wrote it down.
But don't you have to have, in summary judgment states, aren't you required to come forth with your evidence to suggest, to show that there was an actual meeting in advance? And I don't see any in the record, other than maybe some inferences that could be drawn, but.
If I may, I disagree. I think we'll start with, there's testimony from Bill Powers that he met with Vinson Steele, and that testimony from the oral argument says specifically that he met with Vinson Steele, that he believed he had an agreement, that he discussed a depot, that he discussed an $850,000 credit line. He said that. When Mr. Villarreal, who is the vice president, another officer of Vinson Steele, testified, he testified a few things. One, he testified there was a meeting, Your Honor, okay, before he left. He also testified that Bill Powers, when we asked him, was he wrong? Was he lying when he said this? He said, well, I don't think he is. Mr. Villarreal testified that in that meeting, they talked about a depot, and that they talked about Vinson expanding in the valley in January in that, which if you look at, so those are facts, and those are testimony when you ask about the evidence. That's evidence. We also know, and again, now we get into circumstantial evidence, right? We also know that in fact, Bill Powers did get the lowest prices, evidence. We also know is a fact that Bill Powers got a $1 million credit line. We know he got that credit line, Your Honor, in a method that his CFO said he was surprised at how he got that $1 million credit line. We know that there was a Dun & Bradstreet that said, and I might be wrong on this figure, but the point will be clear. I think they recommended $2,000 in a credit line for Bill Powers, and he got $1 million for the credit line. We know that too. That's a fact that the jury can hear. When you look at the inferences that you asked me, we also know that Bill Powers took Powers' information while he was there. He took information on the pricing of rebar. He took that on December 1st, 2017. Prior to the meeting that Mr. Villarreal said he thought occurred a few days before Bill Powers left or resigned. He resigned December 20th, which ties to the December 16th or 18th date that was on that form, which again, whether he submitted it on that date, I think it's mildly immaterial. The question is, does it memorialize this conversation, and does that date as it was written down demonstrate that he had that while he was an officer and a director? And then did he breach his fiduciary duty? There's also a factual question where Bill Powers testified that he also bought $7 million worth of steel between October and December, which was, there's been testimony from Janet Powers, testimony from the CFO Powers, that there was an abnormally large amount of steel. We had to send back, I believe, $4 million worth of that because there's testimony that tapped out our credit line, which does, when you look at the inferences, Your Honor, you see Power Steel financially is stressed. You've got prices for our steel vendor. There's testimony that we couldn't go to someone else because we have years of history if we were to go to another steel vendor that's charging us higher prices, charging Bill Powers lower prices. There's testimony that in the rebar business, it's a race to the bottom. It's a bidding process, no different than state government in the sense that you bid on services. So if you have the lower steel price, you're going to be able to bid lower for the job. And if Powers is paying a higher price, they're going to have to bid higher because you have to make a profit unless, loss leaders get difficult. But there's all that testimony. When you take it in the light most favorable, it's fair, and we believe a jury should hear, and a judge shouldn't be able to determine that anything after Bill Powers left shouldn't be considered circumstantial. That's just not the law in Arizona. Circumstantial evidence is relevant. And two, if you look at Standish, the case we cited as Standish, it talks about that if you begin a breach of fiduciary duty, that fiduciary duty carries till its completion. So if there is a meeting, again, in the light most favorable, that occurred in December 16th or 18th, where they reached this agreement, that the carrying out of that agreement, which is, we'll give you the favorable prices, we'll give you $850,000, we will we will basically put you in business, carrying that out continues beyond when he left. And again, I'm not asking this court to determine the merits. What I'm asking is, when you look in the light most favorable, is there a triable issue? And I think the answer is yes.
One of the things that I'm noting from your argument today
Sure.
is you keep referencing officer and director.
I do.
A lot of your brief is spent on the shareholder issue, and you don't seem to be urging that as strongly today. I'm wondering if that's intentional.
It's not intentional, but I'm trying to obviously lead with the clearest and strongest argument in the facts. The shareholder argument, and I'm happy to address it if that's all right with Your Honor. I'm not waiving it by any means. And I would say, and let me step back, under Standish, if in fact, which the law is a Standish citing Utah law actually, is that you have this agreement in the light most favorable and the fiduciary duties continue as it's completed, I'm not sure the court needs to reach the issue about whether or not a shareholder, whether
It's a separate count.
It's a separate count. And we think that is also a triable factual issue. So the question with that, Your Honor, has to do with, and even if I take Appleby's argument where we're talking about control, the question of control is a fact issue the jury can attest. As we've pointed out, Bill Powers filed an amended complaint that he verified in which he said there was an agreement for himself and the other 8 shareholders to participate in controlling the management of the company. And if you look in the light most favorable to us, a jury would have a right to make that determination, which is, did he breach his fiduciary duty as a shareholder, if they have to get there with the jury verdict? And that, too, is a factual question under Arizona law. So I'm not by any means abandoning that. I'm not in any means saying that that isn't his right. I'm saying, similar to the other, we have fact issues that we've raised, and Bill Powers himself, by filing, as the court knows, an amended complaint under oath that he verified, is making that statement, and we, as a result, then have the ability to ask a jury, as a matter of factual questions, to determine that. And what we're asking for, as we up today, and what we ask the court in summary judgment, we're not here on us moving for summary judgment. What we ask the court to do is let a jury decide that. There are questions of fact, which we believe, and there are ample questions of fact, to say the least, that I think when you look at them both individually and in totality, allows a jury to hear that matter.
Let me ask, because I want to make sure I track your argument.
Sure, Judge Gass.
It seems now, with what you've said today, you're saying that the December 17th, you agree that that's not correct as far as the date that was actually submitted. But what you're saying is that evidence is a meeting in December of 17, is what your argument is.
Sorry, no, you're not. I just wanted to, because my counsel was whispering in my ear, I wanted to make sure I didn't say something incorrect, which is, there's no dispute a meeting did occur, just so we're clear. A meeting occurred. And so what I'm saying is, candidly, I can't dispute or not, I didn't submit it, but I'm not arguing that I'm arguing it's not relevant when the application was submitted, that it memorializes the meeting. So I'm not, in a sense, I guess I'm saying I'm not disputing it. I don't know if, in fact, when he did submit it. But my point is, as I was making, is that it memorializes that. And what I do think, if I want to be hyper-technical, but again, if you look at what was produced to the bank, the date is crossed out and changed to January. So that's why to Judge Morris's question, I said, I don't know when he signed it. I think he might have signed it in December 16th or 18th of 2017. But then he might have crossed it out and submitted it to the bank in January. But my point is the memorialization. And with that, I'd like to reserve, I'm looking at the time here, I want to reserve my time for rebuttal, if that's okay with the court. There's no more further questions.
Just under 7 minutes left.
Okay, thank you, judges.
Good morning, may it please the court. My name is J.C. Petrus-Choyu. I'm appearing on behalf of defendants.
How do you pronounce your last name again? I'm sorry.
Petrus-Choyu, just like it's spelled.
Could you say it one more time, a little louder? I'm sorry.
Petrus-Choyu.
Pasharadze?
Petrus-Choyu.
Patras Choyu.
Yes, yes, Your
Thank
Honor. And I'm here on behalf of defendants Vinson Steel, LLC, and David Villarreal. The question before this court is whether or not to affirm entry of summary judgment at the trial court level. This court should affirm entry of summary judgment. The issue before the court is whether or not there is a genuine dispute of material fact, and I stress two words there, genuine and material. There is not either. There is no genuine dispute because there was no partnership agreement, which is the cornerstone of the plaintiff's argument. The plaintiff argues today, oh, we know for sure there was a meeting. Well, that's not really true. What Bill Powers, and I'll refer to him as Bill since everybody's last name is Powers here, what Bill testified to is that he had communications with Vinson Steel regularly. And so when he's giving his evidentiary hearing testimony on August 20th of 2018 in another case, being examined by the same attorney that we have here today, he is led to various dates. He does not ever say the date of December of 2017. That date is suggested to him. The date, in fact, now he's talking about crossing out the month and changing it. Well, he never crossed out the year. The year was always 2018. And he eventually gives very vague testimony about various conversations. And at some points he says, well, I kind of remember having a discussion sometime around February of 2018. And counsel says, well, December of 2017, that would have been around that time too, right? And so he kind of says, well, yeah, I guess. I don't really remember when all those things happened. So Bill Powers never testifies about a single meeting. Meanwhile, Mr. Villarreal testifies about one meeting that he recalls while Bill Powers was still an employee at Power Steel. And what he recalls is going over and seeing this man that he's been doing business with for 20 years, who is not himself, who is emotional, who is distraught, and who is vaguely talking about having some kind of family dispute. Mr. Villarreal doesn't really know much about it.
Wasn't Mr. Villarreal's testimony or statement that was 2 to 3 days before Mr. Powers, Bill Powers resigned?
That was his best estimation.
That's the day the only evidence I saw in the record that he learned, that Vinson had learned that he was leaving was 2 to 3 days before.
Right, and even at that point, he didn't even know for sure whether Bill was going to be leaving. Bill had announced to Power Steel over a month before that he intended to retire. And David Villarreal, at the latest, or at the earliest, learned that Bill was thinking about leaving the company 2 or 3 days before his last day at the company. So the testimony at the evidentiary hearing is not reliable. I think the court is correct that there is no evidence that contradicts and establishes that there was a meeting, that there was a partnership agreement. There is only testimony from Bill, which was taken out of context and misconstrued, and which he later clarified. That is not a weighing of evidence.
Isn't that pretty classically a weighing of evidence? I said X, now I'm saying Y, and somebody has to decide which is correct.
He did not say X and then Y. He said X and then clarified what Y was, and the trial court specifically addressed that issue and looked at exactly what was said and looked at the affidavit and determined that it was not inconsistent, but that it was a clarification of what he had said previously.
Let me ask you this, was it a material fact? Let's say we find that there is a dispute on that.
Sure.
And that, okay, maybe it is. Is it material? Does it make the point? There's two aspects to it.
Right. And one last thing about that, that initial issue on genuine, we're talking about not just not one meeting, but not one application. The exhibit that Bill Powers was testifying about was actually several items, several applications put together, and the document that the plaintiff now says, oh, that memorialized an agreement, that was a document that on its face would have been dated at least April of 2018, so well later. Now, as far as whether it's material, no, it is not. Because even if this court determines that there was a question and we're going to view the facts in the light most favorable to the plaintiff, and we'll say, yes, there was a partnership agreement. That is not a breach of fiduciary duty. That would have been lawful preparation to compete under Taser versus Ward. So what we have, the three elements that frankly the plaintiff has made up about this partnership agreement are that there was an agreement to serve as a depot in Phoenix for Vinson Steel, an agreement to extend a line of credit, and an agreement to provide preferential pricing. There's no dispute that there was never a depot. So we're talking about something that just never happened, whether with Powers Reinforcing or any other company. There's no dispute that the Powers Reinforcing fabricators did not incorporate until January of 2018 and then did not purchase steel until February of 2018. So it's granted formally a line of credit in January. It does not actually use any of that. And so an agreement, even if you find that it's true, to extend some credit back when Bill was still an employee of Power Steel, would not have been a breach of fiduciary duty.
So under Taser, is it a matter of law that that was just a preparation for lawful business, or is it a matter of fact that the jury needs to decide?
It is a matter of law, and Taser also cites to a case from Maryland where they have facts much closer to the ones that we have here, where they determined that as a matter of law, that is a lawful preparation to compete. And then the third aspect of the agreement would have been preferential pricing, setting aside that Mr. Villarreal has explained that's not a thing that happens in this industry. We're talking about a commodity where the pricing is determined on the basis of every single order. How much are you going to order? When are you going to order it? How do you want it delivered? That's how pricing is determined. But even if you set that aside, an agreement to provide pricing at some later time is manifestly preparatory in nature. So even if you have a partnership agreement, you still don't have a material dispute of fact because it does not matter. Even if you decide that there is both a genuine dispute of fact and that it's material, Power Steel still loses, because what we're talking about is a theory of secondary liability. This is aiding and abetting a breach of fiduciary duty. Setting aside that this court, incidentally, in January of 2021, in the other case, noted that Bill Powers himself has not breached his fiduciary duty. And two trial courts have determined that in what I call the Walsh case, the other litigation. But even if you determine that Bill Powers, in fact, did breach his fiduciary duty, Powers Steel still needs to show that the defendants in this case had knowledge and substantially assisted. When they first find out that he's going to be leaving Power Steel days before he actually does, that simply cannot meet the standard necessary to show knowledge that he was breaching a fiduciary duty and substantial assistance, because they're coming in too late even if they wanted to substantially assist and cause an aid and abet a breach of fiduciary duty.
Your assessment, though, if we find that there was no fiduciary duty, you don't really need to get into the aiding and abetting?
I agree.
So if we say there was no fiduciary duty owed, we're not going to go down the standard road, then we really don't need to talk about aiding and abetting at all.
I agree. And with respect to whether he owed a fiduciary duty as an employee, I think the law is clear that he does. But certainly once he is only a shareholder, and critically a minority, non-controlling shareholder, the Arizona law is very clear that there is no basis under which to impose a fiduciary duty.
Was he a voting shareholder or a non-voting shareholder?
He's a non-voting shareholder. There are 7 shareholders. He is one of those shareholders is Alice Powers, the matriarch. She owns all the voting rights. The other 6 shareholders simply own an ownership interest, but with no ability to control the corporation. And in fact, the plaintiff repeatedly says, oh, they're all board members, but this is purely notional. There are no board meetings, there are no board minutes, and when the witnesses, I believe it was Janet Powers, was pressed on whether or not there was ever a board meeting, what she said was something to the effect of, well, I've been on the phone with my family members before, and so that counts as a meeting. But clearly, there's no ability to control the corporation there. So there's no basis under which to impose any fiduciary duty as a shareholder where the shareholder has no ability, and quite frankly, in this case, is being oppressed as a minority because now he has these shares and he cannot sell them, and otherwise he cannot do anything with those shares. With respect to the tortious interference claim, plaintiff has to show that there was some improper conduct, and they are unable to do that. In fact, really, the whole theory of liability doesn't make any sense. What we have is a company that's been selling steel to Power Steel for 20 years. They also sell steel to other developers here in the Valley, and their interest is selling as much steel as possible at the highest prices possible. The theory here is that for some reason they decided that they were going to help a startup company in the form of Bill Powers Reinforcing Fabricators, and jeopardize their relationship with one of their largest customers, historically speaking, in the Valley, for no reason, and that simply doesn't make sense. In fact, what they wanted to do was gain a customer, not gain a customer and lose a customer, and their actions are consistent with that. The plaintiff says, oh, it's a fact that Power Steel got the highest price and that Powers Reinforcing Fabricators got the lowest price. That's not true, or at least it's not completely true. The complete truth is that Bill Powers is a fabulous negotiator when it comes to buying rebar. And when he was with Powers Steel, he negotiated the lowest price for Power Steel. Why would Vinson be selling steel at the lowest price possible if they were just trying to help out Bill and hurt Power Steel? And then when Bill leaves and starts his own company, he continues negotiating a low price for the rebar that he's buying, and he is able to do that because he's buying a large quantity, whereas Power Steel is, quite frankly, shuttering its own operation and not buying a lot of steel and therefore not getting a competitive price. One final aspect, which is fatal to all of Power Steel's claims, is damages. Power Steel is never able to establish damages. Power Steel only has one piece of evidence with respect to damages, which is its own expert's testimony. But as the trial court found, the expert's opinion is completely lacking in basis because he did no causation analysis. He only calculated the amounts. And when he did his calculations, he was not even aware that Power Steel was shuttering its own business and that there were other reasons that Power Steel was hemorrhaging financially. In fact, what the trial court found was that not just that Power Steel passively failed to disclose documents and information with respect to the reasons that it was failing, but that it affirmatively sought to hide and shield relevant evidence that should have been disclosed. For example, there was a consultant who was retained as a result of a revolving line of credit with a bank for $15 million. That consultant was never disclosed. That consultant was Dan Wiggins. And then when we served discovery requests to find out what that consultant had to say, the plaintiffs asserted that there was a privilege there. The court looked into that and found that there was, in fact, no privilege that applied there, that the consultant was not retained for the purpose of litigation, and that really was just a question of hiding the real reasons. And if the court takes a look at the records that we have from UMB Bank, that tells the whole story. There you have the bank that is doing its due diligence to explore the bases for this substantial loan that they have, And when they go through all the reasons that Power Steel is no longer a worthy credit risk, none of those reasons have anything to do with Bill Powers, with Vinson Steel, with Powers Reinforcing Fabricators, with competition. They all have to do with the fact that the new management is not capable of running the business, and that they are actively trying to shut down the rebar business, and that the only reason that they keep running the business to any extent is because they are worried about contingent liabilities for contracts that they have already entered. So Power Steel fails because it is unable to establish any damages with respect to any of the 3 counts that it has brought. So again, there's not a dispute of fact. It's not a genuine dispute of fact. It's certainly not material. And Power Steel fails because it is not able to establish the knowledge and assistance element necessary for secondary liability. It is not able to establish the damages that it would need to get to a jury. Are there any questions?
Well, thank you for your argument.
Thank you.
Got about just under 7 minutes.
Thank you, Your Honor. Let me start by saying is you heard Appley's argument and talking about facts like there were other reasons Powers went out of business and things like that. And the point that I want to highlight to the court is that what you're hearing is competing stories and competing facts. And that are jury questions. That are triable issues of fact. And that's what we're here for today. Counsel talk. Sorry, Judge Gass.
I'm going to cut to a chase on an issue.
Sure.
Which is if we don't accept your argument that Donahoe should apply, I said Sandy Joe here, it was Donahoe. Do we go any further? I mean, what is the issue after that if we don't believe the Donahoe standard for the minority shareholder?
Well, there's, okay, well, if I can. So there's conduct where no one disputes there were fiduciary duties that Bill Powers, where he talked about the meeting when he was an officer and a shareholder, when he was at Power Steel.
You're talking employee duties, right?
Correct. So I just wanted to clarify. Correct. With respect to the employees, if you find Donahoe doesn't apply, I would respectfully argue that it's a fact question to determine whether or not you look at it's a closed corporation and whether or not he had control to be consistent with these court's ruling and the Supreme Court's ruling with Funk when they look at, do you have loyalty and you have this trust and the like, that a jury can determine that. So I'm not here asking the court as a matter of law to determine one way or the other whether minority shareholders have a fiduciary duty. What I'm asking this court to do is to be consistent with the prior rulings of the Arizona courts, which is to say, factually, a jury can determine, and there is evidence, like I said, Judge Gass, with respect to the complaint that Bill Powers filed, cutting to the chase, where he said that he had a right to participate, not just him, but he and the other shareholders. And there's testimony, both from Appellees, they talk about in their opening brief that John Powers, not Alice Powers, who had the voting shares that Judge Morris asked about, that Alice Powers ceded control to John and to Bill Powers. So the point that I'm making is both sides agree that this company was not run as it's laid out in paper.
But that would only apply while he was still there, the control.
No, if I may, I don't mean to be too blunt about that. No, because Bill Powers filed a verified complaint where he said, Judge Morris, that he had a right to participate.
No, I'm sorry. The Alice ceding control to Bill Powers would only apply while he was still there. Whatever control she may have ceded ended the day he left.
I think that's unclear because Bill Powers...
You're saying that Alice said, all right, you've left and now competing with us, but I'm still going to let you run the business?
And to be clear, I'm not testifying. What I'm saying, if you look at the light most favorable, given Bill Powers' amended complaint that he filed in a court and verified, Judge Morris, that...
He sued derivatively, though.
He did?
So I
directly and derivatively.
Time more efficiently.
Okay, sorry, I'm directly and derivatively. I just was trying to answer the court's question. I apologize.
Let me touch on damages, because I agree with you. There's a jury question if there's competing evidence. What evidence did you guys submit that the court should have considered as to damages?
Sure, gladly. You have testimony from Bill Powers saying that customers of ours left and went to work with him. Gary Whipple testified that our 3 main customers, Sun Valley, and I'm drawing a blank on the third, they all left and went to work with Bill Powers. Gary Whipple testified that we couldn't, because of the prices that were imposed and because of the fact that Bill was competing,
Is Vinson Steel the only steel supplier in Arizona?
They're not, Judge, but they were our supplier. And we had a history, so when you talk about steel prices, we had years of buying steel from
Isn't
them.
steel a commodity, though? I mean, it seems to me that and maybe this is beyond the record, but it seems to me that the prices are going to be kind of easily ascertainable.
They're not. I mean, it is beyond the record, but I can answer if the court, if you really want to know, they're not. They are in the abstract, but there's all sorts of testimony in the Walsh case, and I think which might be in the record, that people keep their prices confidential because it's such a serious thing and how to get the best prices and things like that. So it's not like where you can figure out what the price of IBM stock is, and it's the same price to you as it is to me. It's not that way at all. And so there's testimony from Gary Whipple that we had this longstanding relationship with him, so we would have never gotten a fair price from someone else. You're going to start out the highest price until you develop this relationship over time. It's a buyer's market, or seller's market, excuse me, on the steel side. And an answer to your question. So if I can just address a couple points that was made by Appellee, I know, which is, he said there was no evidence of an agreement. Well, the law in Arizona is you don't have to have an agreement. I don't have to demonstrate an agreement to say you breached your fiduciary duty, first of all. Second of all, what's not discussed is the corporate opportunity. What he discussed in the 16th and 18th for a depot, for the question, these are all corporate opportunities which were not disclosed and should have been raised and brought to Power Steel. That's a breach of his fiduciary duty as a corporate opportunity. The question about the testimony and the clarification, and as Arizona courts have talked about when they look at the sham affidavit and the like, the clarification that could have been made, and again, getting the weighing evidence that I answered earlier, was from counsel for Bill Powers. And just to be clear, there was a judge at that evidence, it wasn't just a deposition, this was an evidentiary hearing. You had a judge on the bench, Bill Powers had his own lawyer. I was cross-examining him. He had the opportunity to clarify, and the issues were the same. So he had every interest to try and do that. What you have on the other side, obviously, is an affidavit that was basically requested by the court, given in the face of summary judgment. There was some discussion about the Maryland Metals case. I just want to be clear. That case, which I think helps us, or points my point, that was after trial, Judge. There was a trial. The standard was totally different. And in that case, they said there was no corporate opportunity. Here we have corporate opportunities. With respect to aiding and abetting, the law in Pope makes it clear that it's whether or not, again, in the light most favorable to us on a de novo standard, whether the actions by Vinson, which was reaching this agreement, a credit line, and the like, makes it easier for Bill Powers to breach his fiduciary duty. And the question's undeniably yes. And the testimony from the Gary Whipples, from John Powers and the like, clearly when that agreement, which we saw reach fruition, that made it easier for Bill Powers to breach his fiduciary duty, and as a result, harmed us. We've lost those customers. To put a finer point on it, the rebar business is out of business. We're talking about a company that has been shuttered when you ask about damages. There is no question. If it stems from, and a jury can determine that based on his breach of fiduciary duty while he was either at the company or continuing in that agreement or elsewhere, they're harmed, and they could prove that amount.
Counsel, you're out of time.
Okay, thank you, Your Honor.
We thank you both, Mr. Patraschoyu.
Yes, Your Honor.
Thank you. And Mr. Quinlan, thank you both for your briefing and your argument today. You've given us much to think about. We'll take the matter under advisement and issue a written ruling in due course, and we are adjourned.